Hey, I'm Matt Geiger. How did our system of abortion laws in America become what we have today? This video is all about the history of abortion and abortion laws in the US. So the initial laws and attitude towards abortion came over from English common law. Basically, that said abortions are legal up until quickening, which was when a woman could feel the baby moving. That typically happens around 15 to 20 weeks after conception. Starting in the mid to late 1800s, individual states began to restrict and ban abortions outright, though. And they did that for a few reasons. One reason was that dangerous methods and practices were starting to be used to have abortions. Another reason for state laws against abortion was that doctors and the American Medical Association began to turn against them. Science was advancing and doctors were learning that quickening was just sort of an arbitrary, unimportant step in the whole development of a fetus. On top of that, abortions weren't done by doctors, they were done by midwives or people who weren't trained. Doctors were concerned about the public health implications of having untrained people doing abortions, not to mention the fact that these sorts of people were cheaper than doctors. As individual states began passing abortion laws, the issue was eventually picked up at the federal level. The Comstock laws were passed in 1873, and that made it illegal to send anything through the mail that was obscene, lewd, immoral, or indecent. It also became a misdemeanor to have an obscene book, picture, drawing, or ad. For our purposes, this law included instruments used in abortions and writings about abortion or contraception, even if they were in a medical context. States' abortion restrictions accelerated through the late 1800s, and by the end of the century, it was a felony in every state to have an abortion, with some limited exceptions like protecting the life of the mother or cases of rape or incest. These laws didn't necessarily stop all abortions, though. It was not uncommon for women to just get them done illegally. Because of that, one woman specifically became really concerned about the number and frequency of self-induced abortions that she was seeing, and that woman was Margaret Sanger. She noticed there was a lack of information on preventing unwanted pregnancies, mainly because of those Comstock laws that prevented it. So Margaret Sanger started the American Birth Control League in 1921, which would go on to become Planned Parenthood in 1942. Margaret Sanger set her sights on changing those federal and state Comstock laws with the ultimate goal of preventing unwanted pregnancies, her main priority being contraception. In 1936, Margaret Sanger helped orchestrate the case United States versus One Package, which overturned a federal Comstock law, making it legal to mail birth control across state lines. This paved the way for the approval of the birth control pill by the FDA in 1960. Lots of people haven't heard of the Supreme Court case Griswold v. Connecticut, but this actually becomes the origins of that right to privacy from government intrusion. In that case, the Supreme Court ruled that states could not pass laws preventing birth control pills since it violated a basic right to marital privacy. In the late 60s, some states began to liberalize a lot of those abortion laws from decades earlier, so that prior to 1973, 30 states still banned abortion in all forms, 16 states banned abortion except in cases of rape, incest, or health threat to the mother, and 4 states just straight up allowed all abortions. These state laws were all overturned, though, in 1973 by the Supreme Court ruling in Roe v. Wade. In a 7-2 decision, the Supreme Court decided that a woman's right to choose whether or not to have an abortion was ultimately protected by that right to privacy that was implied by the Due Process Clause of the 14th Amendment. The Due Process Clause says, "No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law." The Supreme Court talked about a right to privacy, but the Supreme Court also talked about there being a trade-off among conflicting interests. So they set up the trimester system to account for that. In the first trimester, the state could not regulate abortions. In the second trimester, the state could create laws related to maternal health only. And then in the third trimester, states could regulate however they wanted, except when the life or health of the mother was at risk. This trimester system stuck around until the early 90s. In 1992, the case Planned Parenthood v. Casey upheld the central holding in Roe v. Wade that the right to have an abortion is protected by the Due Process Clause of the 14th Amendment, but the Supreme Court got rid of that trimester test. The new test asked whether or not a state regulation imposed an undue burden on a woman trying to get an abortion. The Supreme Court also ruled that viability, the point at which the fetus could theoretically survive outside the womb, was now the new cutoff for other abortion restrictions. Before a fetus reaches viability, states can't impose restrictions that create that undue burden on women. And then after viability, states can restrict abortion except when the mother's life or health is at risk. In 2003, Congress passed and President George W. Bush signed the Partial Birth Abortion Ban Act, which, as its name kind of implies, banned partial birth abortions. So banning the method that was used. This would typically be done in the second trimester, which is a restriction prior to viability. So naturally, it went to the Supreme Court in the case Gonzalez v. Carhart in 2007. In yet another 5-4 decision, the Partial Birth Abortion Ban Act was upheld as constitutional. The Supreme Court decided that it was not an undue burden on the woman's right to an abortion because it applied to only a specific method and other methods were available. So in response to that perceived conservative shift on the court and a softening of what constituted an undue burden, a number of different states started passing lots of regulations on abortion clinics in the name of better health, like requiring abortion clinics to have expensive hospital-grade facilities and requiring abortion doctors to have admitting privileges at a local hospital. And that led to significant abortion clinic closures in a lot of states. The Supreme Court stepped in again in 2016, ruling 5-3 in the case of Whole Woman's Health v. Hellerstedt, that these sorts of laws were an undue burden on women seeking abortions, which meant that they were ultimately unconstitutional. So that really takes us right up to the present. Lots of states are still passing laws intended to chip away at previous Supreme Court rulings, and the line on abortion seems to shift with each new court case. The weighting of the 4 factors of the right to privacy, women's health, human life, and precedent of previous court decisions will probably be settled by the most moderate of the conservative judges in the years to come. Thanks for watching.